Thank you. Good morning. I'm Professor Kath Gelber. I'm an internationally recognised scholar in the field of freedom of speech and the regulation of harmful speech. So I'm appearing to you today in this expert capacity.
Thank you, Professor. I'll now invite you to make an opening statement. At the conclusion of that, we'll open up for a discussion.
Thank you. It's a very brief opening statement. I'm a Professor of Political Science and Associate Dean Academic in the Faculty of Humanities, Arts and Social Sciences at the University of Queensland. Since I completed my PhD on the topic of the operation of hate speech laws or vilification laws in Australia in the year 2000, I've dedicated my career to investigating the operation and effects of vilification laws, considering the rationale for the introduction of vilification and hate speech laws, and examining the appropriate balance to be sought between protecting freedom of expression on the one hand and limiting harmful speech on the other. So I'm well versed in the rationales for protecting freedom of speech and the reasons for limiting hate speech. I've investigated freedom of expression and regulatory responses in Australia, the United Kingdom and the United States, and I've also developed a clear definition of hate speech, which is well recognised and utilised in the international literature. Thank you.
Thank you, Professor. So why don't you start by, for the purposes of the committee, outlining where the threshold of freedom of expression and freedom of speech ends and hate speech begins? Where's the clear delineation?
Thank you. So in theory, the clear delineation is harm. And by harm, I mean a substantive harm that's equivalent, in Australia at least, to other discriminatory types of harm. So it's a harm that happens through your expression that's equivalent to the harm that would happen, for example, if you were to deny somebody a job on a discriminatory ground. So it's more than offending somebody or hurting their feelings. It's when it amounts to a substantive public harm. The way that I conceptualise that harm is that the acts that lead to it need to be public. The expressive conduct needs to rank people as inferior, legitimise discrimination against them, deprive them of powers in a context in which those people are vulnerable to that harm. And that means, for example, that groups, the marginalised groups that face discrimination in Australia today, for example, are vulnerable to the harms of hate speech. So that's the theory. In practice, delineating whether or not an instance of expression has crossed that line is complex and depends very much on the context within which it occurs and the other things that happen alongside the expression. So there are some examples that are really, really clear and there's really no debate over them at all. Those include, for example, the kinds of conduct that have recently been prohibited in a number of jurisdictions in Australia, such as the use of Nazi symbols and gestures, right? So they so clearly cross a line into harm that there's actually, in my view, no real debate about that. But there are a lot of other matters in public political debate at the moment, particularly around anti-Semitism, where the lines of distinction are not as bright and clear as that. I wish they were, but in practice, it can be quite complex to determine that distinction.
Excuse me, I've had a bit of a croaky throat for the last few days. What do you mean by it's not as clear in regards to anti-Semitism?
So when an expression is definitively anti-Semitic, it's absolutely clear that it crosses a line. What I mean by saying that it's not always clear is that it's not clear where and when an expression becomes anti-Semitic. So I know there's a lively debate going on in the community about some slogans that have been used in pro-Palestine protests, for example. Now, I don't want to suggest that there isn't anti-Semitism at all in the Australian context of those debates. I wouldn't for a moment try to suggest that. I absolutely acknowledge that there's a very concerning rise in anti-Semitism and in anti-Semitic expression. But I also acknowledge that in the context of those debates, there are differences of opinion over whether or not a particular slogan or a particular phrase amounts to being anti-Semitic or not.
To the best of your knowledge, does the University of Queensland have a definition on anti-Semitism?
I just with respect, like to remind you that I'm not here as a representative of the University of Queensland. I believe the University of Queensland is in the process of watching what's happening, participating in the Group of 8 discussion that I know you've already spoken to the Group of 8 about at the last hearing in terms of developing a definition, and I believe the University of Queensland's involved in that.
Given what you said as an expert on the delineation between hate speech, sometimes the extra attention that is required in order to decipher whether something is anti-Semitic, given the complicated nature of the Middle East and the way in which this conflict can be spoken about, do you think it would be in the universities? It would be appropriate for the university to adopt a definition on anti-Semitism?
I think that, yes, I think in the current context, it's quite useful for universities generally in Australia to consider adopting a definition, yes. I'm not entirely 100... So the question that raises for me is, until now, anti-Semitism has been treated, certainly legally in Australia, and members of the Jewish community have advocated strongly for this, for anti-Semitism to be treated as a type of racism. So it's recognised as a type of vilification under relevant anti-vilification laws, and it's recognised as a type of racism under relevant anti-discrimination laws that recognise racism as a ground. So in that context, I guess one of the questions that's raised about incorporating a definition of anti-Semitism, which I'm not personally opposed to, but the question that raises is whether we would then find ourselves in a position of being asked to develop definitions of other specific types of racism as well. There's no doubt that the manifestation of racism towards different groups occurs differently. And so that's the question that it raises for me, although, as I've said, I'm not opposed to the idea.
Doesn't that answer your question in the way in which you answered it? I mean, it does manifest itself differently, as you just said, and therefore wouldn't it be appropriate to have definitions in order to best understand the ways in which discrimination and racism manifests itself towards different groups?
Well, it depends on what you think the best approach is to combat racism towards different groups. For example, racism manifests towards Australia's First Nations people, towards Aboriginal and Torres Strait Islander people in specific ways. We have not tendered in Australia until now to define racism in the relevant statutes in a way that recognises that the way that racism manifests towards Aboriginal and Torres Strait Islander people is different. So, but I think that it is different. So the problem is that there are quite a number of different types of racism that manifest differently, and we would then be in a situation of potentially trying to incorporate definitions of those different types of racism into all of those statutes. And I think there's something useful about having overarching statutes and regulations that address racism in its completeness as a problem, because of course it is.
But we're not talking about legislating, we're talking about the university adopting a definition so that it can understand what form of discrimination or racism is occurring, aren't we?
Well, if that's what yes, we can talk about either of those, but there is a connection between what the universities do or are asked to do around this and other policy, because our internal, of course, universities are regulated by many statutes that already exist in Australia, but also our internal governance documents tend to refer, even sometimes obliquely, to existing provisions. For example, vilification is prohibited under staff and student codes of conduct, and that refers, of course, to relevant anti-vilification provisions that exist in Australia. But certainly as an educative mechanism, as a mechanism for helping people to understand better how anti-Semitism manifests and what it is constituted by, that's a useful thing to do, yes.
And my last question before I hand over to the Deputy Chair, I mean, as being an expert on the hate speech and on the delineation between hate speech and fair and reasonable public debate, isn't a part of that the confidence that students and staff have in the university in actually preventing discrimination and and harm being done, isn't a big part of it the way in which the university transparently and openly have these sorts of policies in order to build confidence in students and staff that they would be protected if that was to happen to them? Do you think that universities adequately have those processes? And I guess you're the closest to University of Queensland, but what's your observations on that?
So absolutely, I think that universities should try their best to have transparent policies that are understood, known and understood by staff and by students, so that reassures them. In fact, in my work around vilification laws, it's been very clear that having those laws in place serves not only an educative purpose but also a reassuring purpose for the communities who those laws seek to protect. So similarly, the communities who we seek to protect, which is all of our community, but also particularly marginalised groups within our communities, should feel reassured and confident that we have those provisions in place. So we do have those provisions. That's not to say that we can't improve them. Of course, we can. The university sector as a whole can always improve its policies and its procedures, and we're in a moment where I think that we're seeking to learn how to do that better.
I'll hand over to the Deputy Chair. Thank you, Professor.
Thank you, Chair, and thank you, Dr. Gelber. My question is sort of more of a broader one. Do we have, through your research, is there anything from an international perspective or maybe domestically where we can sort of identify where some people are doing it better than we are here in Australia, or in some of our universities? Is there particular best practice that we should be looking at?
So I think that that's difficult to identify, and there's a really important contextual reason for that. So there are movements there have been moves in many universities. I know you've already heard about this, for example, in the United States, to develop their own definitions, to develop dialogues across difference, to develop anti-racism statements. There are moves in Australia. Several Australian universities either already have or are in the process of developing anti-racism statements. And similarly to developing more thoroughgoing programs and training, for example, around anti-Semitism. There is an important caveat on drawing from international practices, and that is that one of Australia's strengths, in fact, in my opinion, is the vilification laws that operate in Australia, and in particular the way the civil vilification laws operate in Australia. They're actually almost unique internationally. There are only some provinces in Canada that have something similar, and they allow us to intervene at a lower level, if you like, of vilification than only the types of things that you can intervene against with either the criminal law. So, for example, in the United Kingdom, their racial hatred provisions are in the criminal law only. And in the United States, of course, they have the First Amendment. So the context is very, very different in those other countries. There's no other country that has the experience of the civil vilification provisions and the commensurate expectations and responsibilities on universities in terms of compliance with those provisions. No one else has those. And I think that, so therefore, drawing from international best practice needs to take that context into account.
Okay.
Kylie Tink.
Thank you, Chair, and good morning, Dr. Gelber. I actually have a question with you. I really appreciate everything you've said this morning about the laws that are in place and the ways that we can address it. But how do we better educate people about, have you done work in this space, and where do we begin a conversation or a process in educating people about what anti-Semitism is and what other forms of racism are?
Yes, thank you. So, that's the big question, isn't it? And clearly we need to do more, particularly around anti-Semitism in the current context, because it's my view that people insufficiently appreciate and understand how anti-Semitism is manifesting in the current political debate. People tend to focus on things, the more obvious things, for example, like what happened in Melbourne. Abhorrent events like that, and they tend to downplay the anti-Semitism that can happen through expression. One thing that I think that we can do, and it would be really useful to interpolate this more into the public debate, is to talk more about the responsibilities that connect with our free speech rights. And there's a very clear responsibility when people do exercise their free speech rights not to use their speech to harm others. So it's my view that speech can harm. I've spent my entire career arguing that hate speech can harm and looking at how it can harm by interpolating inferiority and legitimising discrimination in the context within which it occurs. But there's a commensurate responsibility when people exercise their free speech rights to be not to harm others with their words and to be more aware than they currently are that other people will have different interpretations of what they're saying and other people might experience what they're saying in a way that they might not have intended. So there's a lot of work going on internationally at universities about dialogue across difference. It's called different things in different places, communities of inquiry, for example. And I think the central component of those types of projects is to encourage people is to recognise that we don't all need to agree with one another, but we do need to agree a little bit more on the parameters for public debate. And one of those parameters should be not an agreement to try not to harm each other with our words, an agreement to understand that words can harm and to use our words differently.
Thank you. Back to you, Chair.
Thank you. Senator O'Sullivan or Senator Darman or Ms Bellier, any questions, or are we happy to wrap up there?
None from me, Chair.
Okay, perfect. Well, Professor, thank you so much. And